Uh, yes. So, good afternoon, everyone. We will just wait for a minute before we start with the rapid revision of MP Judiciary examination, right? So, we will just take a minute before we start. Good afternoon, Shaktija. Am I audible and clearly visible to you? Yes, Shaktija, if I'm audible and clearly visible to you. Yes, good afternoon, Shaktija. If I'm audible, okay. So we'll just take a minute, okay? We will just take a minute before we start. Now, am I visible, Sakshi? Okay, students, just wait for a minute, okay? We can start then. Okay, so we can start now, students. I hope that I'm audible to everyone and I'm also visible to everyone. So we can start before we start with the section wise explanation. Okay, rapid revision. I would like to give you the important sections, right, of IPC, which you cannot miss. Though all sections are important from the point of view of preliminary examination, but there are some sections which you cannot miss because they have been repeatedly coming in MP judiciary, and also important for the from for mains purpose also, right? So you cannot miss it. So before I can start, I hope I'm clearly visible and audible to everyone, and my screen is also visible to everyone, right? My screen is visible. Shaktija, Sakshi, those comments are, I'm getting comments from these students. What about others? Please give me a green flag so that we can start. If my screen is visible to everyone. Yes. For Yash, the screen is blurred. Okay, Yash. So when I will start giving the important things, also I will make it sure that you get the sections in the chat box too, right? So for those who cannot see the screen clearly, I will be posting the important sections in the chat box only. And if I think if you people are those who are in laptop, those who have are watching it on laptop, for them it will be clearly visible. Those who are watching it on phone, it might be slightly blurred, right? Okay. Also, tell me one thing before I can start. How many chapters are there in IPC and how many sections is it divided into? How many sections and how many chapters is IPC divided into? Please give me an answer for this. Yes. Sakshi, Yesh, Shaktija, Chavi. How many sections are there in IPC and how many chapters are there in IPC? 511 sections is the correct answer. But how many chapters? Yes, Khushi has given the correct answer. There are 23 chapters and there are 511 sections. Very good. So those who are writing 23 chapters and 511 section, you all are correct. Now, as you can see my screen, let me start. Today we are not going to do all the 23 chapters. Today I'll keep it till, I'll try to complete till chapter 15 at least. Okay, I'll try to complete till chapter 15. So today we have part 1 of IPC. Part 2 will be continued tomorrow. So as you know, chapter 1 is the introduction chapter, and from section 1 till section 5 you have to read everything. Chapter 1, which is the introduction chapter, right? Section 1 till section 5. Questions come from section 5 a lot, though, in MP Judiciary. I've seen questions coming from section 5, but please read from section 1 till section 5. Chapter 1, which is the introduction chapter, it is from section 1 till section 5, right? Yes, is it visible to you clearly? Please read section 1 to section 5. I'm also writing this in the chat box because those who cannot see my screen clearly, they can, these are the important sections which I am giving you all, okay, which comes in MP Judiciary. Then come to chapter 2. Now chapter 2, you will see chapter 2 is the general explanations chapter. Chapter 2 is the general explanations chapter. It is starting from section 6 and it is continuing till section 52A. So there, these sections are important. I hope it is visible to you all. And still I am posting in the chat box also for those who cannot see my screen clearly. From chapter 2, which is the general explanation chapter, general explanation, you have section 6 to 52A. We have from section 6 to section 52A. These are the important sections. Now see, all sections are important, but I have jotted these sections down from the previous year MP Judiciary preliminary papers. Seeing the trend, I have jotted down these sections because these sections have been repeatedly coming in the preliminary examination for IPC, right? Also, since I'm marking it in the I'm posting it in the chat box, I don't think there will be any issue now. Now let me move on to the third chapter, which is chapter 3. Now chapter 3 is of punishments, right? Chapter 3 is of punishments, and it is from section 53 to section 75, right? It is from section 53 till 75, right? So these are some important sections which I have marked. Also mark 54 and 60. Hope all of you are marking it in your Bear Act. If you don't have the bare act with you right now, please grab it. And if someone is looking doing it from online, then please write it down in your in a piece of paper at least. This is from chapter 3 of punishments chapter, which is from 53 till 75. Now, when I'm starting to give these important things, you are also getting a revision of which chapter is, concerned with what thing. Like chapter 3 is concerned with punishment, and it is from section 53 till 75. So, all these things also, please revise it in your mind again. Come to chapter 4 now. Chapter 4 is the general exceptions chapter. Now, in this chapter, I don't want to give any important thing, but these are from the past years. Okay, these have been repeatedly coming in the past years, so I think you should stress on these sections. But I think from the point of view of preliminary examination or any examination, all sections are important. All sections of chapter 4 are important. So I don't want to give any importance here, but previous years, these are the sections which came in previous years. Okay, 77, 78, 82, 87, 92, 94, 95, 97, 99, and 100. So all sections of chapter 4 are important, but if you want to lay stress on certain sections, then these are the sections to lay stress on, because they are from the previous year questions. Okay. The sections which I have given here are from previous year, but please go through all the sections of chapter 4. It's a really, really important chapter. I don't want to mark anything important here. Okay. Now coming to chapter 5. So before I can move on to chapter 5, I want to know from you all, what is the name of chapter 5. Chapter 5 is concerned with what heading? I'm not going to tell you all will be telling me. What does chapter 5 what is chapter 5 concerned with, and from which section to which section? What is chapter 5 of IPC concerned with, and what is the section which is dealt with under chapter 5? Please give me a fatafat, give me an answer. Very good, Khushi. Abatement, very good. Very good, Khushi. Abatement is the correct answer. And what is the section of abatement? From where to where do we find this chapter of abatement? It starts from which section? Since chapter 4 is still 106, then abatement is starting from section. Start answering, students. Yes, very good, Khushi. Very good. It starts from 107 and ends at 120. Very good, Khushi. So chapter 5 is from 107 to 120. Now again, this is a very important chapter, but ये previous year के trends है, okay? So go through all the sections in this chapter. All sections are important, but the sections which I have marked is from the previous year. ठीक है? But these are the previous year sections which have come in the past 5 to 6 years. You can find these sections. Marking it here, right? The sections where I'm marking are important, but I have given is that means it is from the previous year. Now, before I go to chapter 6 का slide, please tell me chapter 6 क्या है और उसमें कितने सारे sections हैं. What is chapter 5 and how many sections are there? Chapter 5 we have already done. Now, after chapter 5, do we have chapter 6 or do we have some other chapters? So after chapter 5, what is the chapter coming in? What is the name of the chapter which comes in after chapter 5? No answer coming. Please tell me the next chapter name. Very good, Soumya. Yes, Sahu has also written conspiracy. Very good. Criminal conspiracy, and the chapter is 5A. Very good. So after chapter 5, we don't have chapter 6. We have chapter 5A, which is criminal conspiracy, and both the sections are important, right? In this chapter of criminal conspiracy, you have to do both the chapters. Very good, Soumya, Khushi, Shaktija. Yes, it is 5A. Okay, 5A, not 6A. It will be 5A. Then let us move on to chapter 6. Now, chapter 6 is relating to offenses against state, right? Offenses against state. If you see, chapter 6 is from section 121 till 130. And these are the important sections. These are the important section. 121 is important, 124A is important, right? 121, 124A, to go through 121 and 124A properly. Now when you are doing 121, also do 121A, because related sections you have to do. If I'm missing the punishment wala section, just that is implied that if a section is important, along with it the punishment section is also important. So if I'm missing out on the punishment wala thing, it is implied that you will have to read the section with the punishment part, right? Acha, chapter 7 is not important. I have never seen any question coming from that part, right? So I'm not like, you all can skip chapter 7. Chapter 7 we can skip. Coming to chapter 8, of offenses against the public tranquility. Chapter 8 is offenses against public tranquility from 141 till 160. This section is from 141 till 160, and these are the important sections here. So 141 is unlawful assembly. What is 141? It is unlawful assembly. Who can tell me about 146? What is 146 under chapter 8? What is 146 in chapter 8? What is section 146, student? Come on, 146 and 159. I want to know both the sections. What is 140? Very good, Shaktija. 146 is writing. Very good. And 159, tell me about 159. 146 concerns writing. Very good, Sahu. What is 159? Very good. Very good. 159 is AFRE. So both this section, which you will start with unlawful assembly, rioting, and AFRE, these are very important sections when we see chapter 8, right? Now chapter 9 again is not that important, right? Chapter 9 is not important, so we can skip chapter 9 also. We skipped chapter 7, we skipped chapter 9, but we have to do chapter 9A. Now, chapter 9A is of offenses relating to election, and you have to read all the sections, because जो marginal note है ना इन sections का, वो आ जाता है, वो पूछ सकते हैं exam में, that which is the section of bribery, or which is the section of personation at elections. So they might ask you the section. Right. So I hope you people have written this. Okay. Now let me move to chapter. Now chapter 10 again is not that important, right? Chapter 10 again is not that important, but अगर chapter 10 अगर आप कर ही रहे हो, ठीक है, chapter 10 अगर आप कर रहे हो, तो आप ये sections कर लो जो I am posting here. Chapter 10 से you don't have to do everything. So chapter 10 again is not that important, but अगर आपको करना है तो यही sections, I guess इस section से ज़्यादा तो नहीं आना चाहिए. 172, 177, okay, 170 7, then 181, 182, and 187. If required, they might also ask you 178. एक बार read कर लेना, 178 to 180 एक बार read कर लेना कि क्या है वहां पर. Only refusing to sign statement, refusing to answer public servant who is authorized to question, ये सारी चीजें हैं. उतना important नहीं है, but फिर भी अगर आपको करना है तो यहाँ पर आप ये 7 sections आप कर सकते हो, right? ये 7 sections आप बस उसका marginal note देखना है. Coming to chapter 11, right? Chapter 11, which is of false evidence and offences against public justice. It is from 191 to 229A. So 191 is important, 192 is important, 201 is important here, right? So ये सारी कुछ कुछ चीजें हैं जो important है, जो आप देख लेना एक बार. Just remember that what do this section contain, what are they talking about. बस इसको बहुत डिटेल्ड में नहीं पढ़ना है आपको, बस सेक्शन रीडिंग करना है. लाइक चैप्टर 4 यू हैव टू रीड इन डिटेल, अबेटमेंट यू हैव टू रीड इन डिटेल, क्रिमिनल कॉन्स्पिरेसी यू हैव टू रीड इन डिटेल. ठीक है, ये सारे सेक्शंस को बस आप ऊपर ऊपर से सिर्फ सेक्शन पढ़ लो. अच्छा, चैप्टर 12 जो है दैट इज ऑफेंसेस रिलेटिंग टू कॉइन एंड गवर्नमेंट स्टैम्प. So go through these section 230, 231 and 232 and 260 also. बस अगर चाहते हो तो 255 भी एक बार देख लेना. इट इज काउंटरफीटिंग गवर्नमेंट स्टैम्प. जस्ट रिमेंबर द सेक्शन, दैट्स इट. ओके. अच्छा, ये सारी जो चैप्टर्स हैं इसमें सिर्फ आपको सेक्शन फ्रॉम द बेर एक्ट ही पढ़ना है. आई डोंट थिंक यू हैव टू गो थ्रू द deep, in-depth study of these sections. Chapter 13 you can skip. Chapter 14 may it's important, right? Coming to this chapter, which is 14 of offenses affecting public health, safety, convenience, decency and morals. इसमें आप ये सारी चीजें, ये जो सेक्शंस है 268, 269 भी एक बार लिख लो, राइट? 270, 271, I think 273 and 274 भी आप just keep it in mind. And then we have 292, 293, 294, which is relating to obscene books, obscene objects, obscene acts and songs. और 294 ए का बस सेक्शन याद रखना कि क्या है. Now these are very bare act centric sections. You don't have to go through a lot of in-depth study in this. Okay. चैप्टर 15 इज नॉट इम्पॉर्टेंट, बट अगर आपको पढ़ना ही है तो एक बार रीडिंग कर लेना 295, 295 एंड 296. दो इट्स नॉट इम्पॉर्टेंट, बट अगर पढ़ना है तो पढ़ लेना. दो इट्स नॉट इम्पॉर्टेंट, Just read from the bare act. So what is important? What is important from this point of view? Chapter 1 is very very important. Chapter 2 is important, right? So chapter 1 chapter 2 को अच्छे से करना है IPC में. Chapter 1 chapter 2 chapter 3. So if I tell you which chapters are important, very important, which you have to do from the point of view of in-depth study. Chapter 1 chapter 2 जो भी sections मैंने आपको बताए. Chapter 3 chapter 4 which is general exceptions. तो बहुत मतलब इसमें आपको इन डेप्थ स्टडी चाहिए ही चाहिए. You have to study in depth. Chapter 5 chapter 5A chapter 6, those sections which I have marked, okay. 8 and 14 में थोड़ा बहुत इन डेप्थ स्टडी चाहिए, अदरवाइज नहीं. थोड़ा ऑप्सीना एक्ट और पब्लिक न्यूसेंस को लेकर थोड़ा सा चाहिए, अदरवाइज नो. सो दीज सेक्शंस हैव टू बी रेड इन डेप्थ. These are very very important section, very important chapters. और जो मैंने sections mark करवाया है उसका आप properly एक बार in depth study कर लेना. This part is clear to everyone? वो भी chapter 1 और chapter 2 में जो भी मैंने important mark करवाया है आप उस पे अच्छे से you go chapter 4 तो you have to read in depth, right? Chapter 4 chapter 5 chapter 5A ये सारी चीजें बहुत अच्छे से पढ़नी है वैसे. ठीक है, इसको आप डिटेल में पढ़ना है. चैप्टर 14 को मैंने चैप्टर 8 के बाद वो चैप्टर 14 है, ओके. चैप्टर 8 के बाद चैप्टर 14 है जो मैंने गलती से एक और उसमें रोमन 5 लगा दिया है, तो वो आप एक बार देख लेना. ओके, सो नाउ वी कैन स्टार्ट with the rapid revision after giving you the importance. Now tell me, what is criminal liability? What are we dealing with in IPC? Who can tell me? What are we dealing with in IPC? We are dealing with in IPC the various principles of uh, you know um, the penal offenses, right? We are dealing here with the penal offenses. So let me just show my screen first. Right. So what are we dealing with here in IPC? We are dealing with the penal offenses. We are dealing with the liabilities which a person has when he commits a crime, right? The liabilities which a person has when he is committing a crime. Very good, Ayushi. Yes, offenses and their punishment. Very good, Ayush. And Ayushi, correct. So here we are dealing with some of the very important things which we have to do, right? Relating to offenses and relating to liabilities also. So when you are committing one criminal offense, and also you have to you have a liability regarding a crime. When you, if you have committed a crime, you have a responsibility, you have a liability for that, right? And that is a ground for receiving a penalty. That penalty will be fixed by whom? That penalty will be fixed by the state for such offense. And the state has come up with the IPC, Indian Penal Code. So if anyone is committing a crime against the offenses which have been mentioned here, which has been laid down by the law in IPC, then you will be made liable for punishment because of your action. So the harm or the loss you are causing to the society will be met up by the penalty which is imposed by Indian Penal Code. Now, when you see the various principles of criminal liability, you will see the general principle is actus reus and mens rea, है ना? क्रिमिनल लाइबिलिटी जब आप आपके ऊपर आती है तो क्या चीजों की, किन चीजों की आती है? यू मस्ट बी वेरी मच familiar with the term actus reus and mens rea, right? Actus reus and mens rea. What is actus reus and what is mens rea? Please write in the chat box. What is actus reus and what is mens rea? Write in the chat box about actus reus and about mens rea. What is actus reus? Mens rea is intention, guilty intention, act done, actus reus. Good, good, right, right. So mens rea is my guilty intention and actus reus is my act done. Very good. And then there is a principle of strict liability. Now the general principle is that you will be punished for your criminal liability, that is your actus and that is your mens rea. Then there is a principle of strict liability also. There are principles of absolute liability also, of corporate liability also, of joint liability also. So the liability which is in criminal law is based on two important elements जो आपको पता है वो है हमारा very good students, you people are have written it correct, right. So actus reus जो हम देखते हैं is a result of human conduct because law is seeking to prevent, right. And mens rea is the guilty mental condition, right. It can be your intention or knowledge or otherwise, so that is giving the crime, if that is giving a liability. Now there was a case फाउलर वर्सेस पैजेट. अगर आपको इस केस के बारे में पता है, फाउलर वर्सेस पैजेट. In this case, the court held, right? The court held, this was a landmark case. So the court held that the intent and the act must both concur to constitute a crime. It's not only action but also intent of a person. Now there are some एक्शंस जहां पे इंटेंट अगर नहीं भी हो तो भी आप क्रिमिनली लायबल हो जाते हो. कैन यू टेल मी दोज ऑफेंसेस? सो द जनरल लॉ इज दैट द एक्ट एंड द इंटेंट both must concur to constitute a crime, but there are some acts जहां पे आपका गिल्टी इंटेंशन नहीं भी है, you did not intended to do that crime but you are still made liable. Kidnapping. Shivani has written. Very good, Shivani. Kidnapping can be one thing. Okay. Criminal conspiracy. Criminal conspiracy trespass. Shaktija has written. Okay, start answering your thing. Where do you get criminally liable even if you don't have the intention? Okay? And I'll just continue with the two essential elements, which is actus reus and mens rea. Now there is a maxim based on this, very important maxim and a very famous maxim, which is actus non facit reum nisi mens sit rea. Right? Act itself will not be criminal unless it is accompanied by a requisite guilty mind. So the act is itself not criminal unless you have a guilty mind also. So without a guilty mind, you cannot be held liable. Right? Acha, then I told you about criminal liability, which is also from joint liability. Now, can you tell me the sections where a person is jointly liable, where you have a joint liability under IPC? So, when I was talking about this criminal liability, I told about the general principles, that is criminal liability in actus reus and mens rea, principle of strict liability, absolute liability, corporate liability, joint liability. Can you tell me the sections which are concerned with joint liability in IPC? Which sections are concerned with joint liability in IPC? See, the sections which are concerned with joint liability in IPC are section 34. Okay, 34, 149. So 34, 149 you have. C34, it is acts done by several person in furtherance of common intention, right? Then we have 149. 149 is concerned with unlawful assembly, and the other sections are 114, 120A, 120B, which relates to criminal conspiracy. 114 is my relating to abatement, है ना? 376D also. After the Amendment Act, 376D has also been added, and it is also attracting joint liability under IPC, okay, relating to rape. What is 376D, students? Gang rape, right? 394 and 396 also. 394 is about voluntarily causing hurt in committing robbery, and 396 is dacoity. So here it attracts uh, joint liability, right? Now, who can tell me the elements of crime? What are the elements of crime? What are the essential elements of crime? Coming again to the maxim actus non facit rem nisi mens sit rea, which means act itself will not constitute a guilt unless it is done with a guilty mind. Fowler versus Paget case, very important, right? So from this maxim only, जो पहले दो एलिमेंट्स हमें मिल जाते हैं ऑफ क्राइम इज एक्टस रियस एंड मेंस रिया, ये तो है ही। इसके अलावा वेरी गुड इंटेंशन, प्रेपरेशन, अटेम्प्ट, कमीशन। नाउ इज इंटेंशन, प्रेपरेशन, अटेम्प्ट एंड कमीशन एलिमेंट ऑफ क्राइम और स्टेजेस ऑफ क्राइम? यस, यस, ये होता है स्टूडेंट्स ऑलवेज गेट्स कंफ्यूज्ड। जब हम एलिमेंट्स लिखते हैं तो हम कभी स्टेजेस भी लिख देते हैं, बट स्टेजेस ऑफ क्राइम डिफरेंट है, इस एलिमेंट्स ऑफ क्राइम डिफरेंट है, ठीक है? नॉट एन इश्यू शिवानी, गुड, यू आर ट्राइंग। ट्राई स्टूडेंट्स, जस्ट ट्राई, गिव योर आंसर्स इन द चैट बॉक्स, गिव इट विदाउट एनी हेजिटेशन, ओके? जैसे ही हम बताएंगे वो हम तभी यू विल गेट करेक्टेड, राइट? सो नॉट एन इशू, आप स्टेजेस को भी एलिमेंट्स के बाद लिख सकते हो उस आंसर में, यू कैन जस्ट ऐड लिटिल बिट। बट एलिमेंट्स ऑफ क्राइम क्या क्या हो जाता है? व्हाट आर द एलिमेंट्स ऑफ क्राइम? ह्यूमन बीइंग, द फर्स्ट एलिमेंट ऑफ क्राइम इज ह्यूमन बीइंग, ओके? एक ह्यूमन बीइंग होना चाहिए। देन देयर शुड बी एन एक्टस रियस, there should be mens rea, and there should be an injury caused to another human being, okay? So there is a human being, and human being has been defined under section 11 of IPC as a human being तो नहीं है, but वो term है person, okay? The term is person. सेक्शन 10 में मैन और वुमेन जो डिफाइंड है वो बहुत इंपॉर्टेंट डेफिनेशन है, बिकॉज आई हैव सीन दिस कमिंग इन एमपी जुडिशरी का एमसीक्यूज, मैन एंड वुमेन का रिलेटेड सेक्शन 10 से related MCQs in MP judiciary. Okay, section 11 is concerned with person, which is what we are dealing with here as human being. And then we have mens rea, that means you have a intention or you have a knowledge, right? And then we have actus reus, that is an act committed. Now act committed or omitted under section 32, 33, 36 of IPC. And harm, where is harm defined? I will not say, you all will say. Where is harm defined in IPC? Of course, in chapter 2, but which section? Tell me. Harm. Where is harm defined in IPC? Harm कहाँ है defined in IPC? Very good, Shivani. Yes. Injury जो है वो है, but what is the section? What is the section? Shivani, just correct the section once. So harm word is substituted by the word injury. You can write. So injury, but which section, students? 44. Very good. 44 defines injury. Now, the question which I asked you कुछ देर पहले कि mens rea is an essential element of crime, but there are some offenses where mens rea is not, even if it's not present, still you are liable for uh, for the act you have done. So though you don't have a guilty intention, but you are being liable for the act done, right? And you people have posted your answers here, so let me tell you. It is kidnapping. So those who wrote kidnapping, rape, selling of obscene material, public nuisance related offences, offences which is dealing with strict liability or offences under Motor Vehicles Act, public welfare offences like food adulteration, environment pollution, है ना? These are offences which do not require mens rea to constitute a crime. ठीक है? So the famous case which was relating to kidnapping, where the person did not have that guilty intention and still he was criminally held liable, was R versus Prince case. R versus Prince case. I hope you all know this case. It was about a person, and he didn't knew the girl is a minor because the girl had an appearance which made her look that she is a major, like she's 18 and above, but she was actually a minor. She was 14 years old, and even though he had no knowledge about that, but he was held liable for it. Okay. So these are the thing. Now now let us come to kinds of punishment which are there in IPC. But before that, I'll just tell you this IPC ka thing. The preamble, as you know, is written here, and it is extending to whole of India. Okay, and section 2 and section 3, if you see, with along with section 4, it deals with extraterritorial offences and punishment for offences which is committed within India, punishment of offences committed beyond but which may by law be tried within India, and extension of code to extraterritorial offences. Now, these are important sections. These are important sections in IPC, right? So, as you can see, the jurisdiction. What is the jurisdiction here given? Please tell me some. Please, someone tell me what is the jurisdiction of IPC as given here. सेक्शन 2 एंड सेक्शन 3 में हम हमें क्या दिख रहा है? Who can tell me? Before we can head to the other sections, please tell me the meaning here of section 2, section 3, and section 4. What is the punishment? See, the title and extent and operation of code is given. It is Indian Penal Code, right? It was established in 1860, right? और हमें सेक्शन 2 में क्या दिख रहा है? आईपीसी का जुरिस्डिक्शन क्या है? Intra-territorial jurisdiction and extra-territorial jurisdiction, which we hear of in IPC. So the jurisdiction of IPC, as you can see, is extending to, first of all, section 1 क्या बोल रहा है यहाँ पर? Section 1 is telling me that it is extending to whole of India. This is my jurisdiction. It is extending to whole of India, right? And now it is applying to the entire country, including our union territory of Jammu and Kashmir after Jammu and Kashmir Reorganization Act. Let me just please have your bare act with you. ठीक है? So when we are doing, you can just mark it. Now section 2 is very important. It talks about the punishment of offences which is committed within India. So section 2 is dealing with what? It is giving me intra-territorial jurisdiction of IPC. सेक्शन 2 में हमें पता चलता है इंट्रा टेरिटोरियल jurisdiction of IPC, which means every person is liable to punishment under this code and not otherwise for every act or omission contrary to the provisions thereof, of which he shall be guilty within India. So we are getting this. Is this clear? Section 2 is clear to everyone. The interterritorial jurisdiction, section 2 is concerned with intra-territorial jurisdiction. So whoever is violating Every person they are talking, okay, every person who is violating the provision of IPC, then IPC will apply to them. Whoever is committing an act or he is omitting to do an act which is violating IPC will be punished. So that means every person who is committing an act in India, he will be guilty within India. That means foreign national also, even if a foreigner is entering India, and if that foreigner is instigating an offense, but if the offense is being committed within India, then he will be liable under this code. And if you see section 3 and 4, section 3 and 4 talk about the extraterritorial jurisdiction. That means what is the punishment of offenses which is committed beyond India, but जिसको हम इंडिया में ही ट्राई करेंगे, right? So 3 and 4 is dealing with the extraterritorial jurisdiction of IPC. Now extraterritorial crimes means जो हम different इंडिया के बाहर कर रहे हैं, right? Section 3 states that if a person is committing an act outside the territorial boundaries of India, लेकिन अगर उसका impact of the act is within the country, then he can be tried under IPC. And section 4 is an again one extension of section 3 only. यहाँ पे हमें दो ऑप्शन मिल रहा है. The provision of this code apply also to any offense committed by any citizen of India who is in any place without and beyond India. So if a citizen of India is outside but he is committing an offense, he can be punished within India under IPC. And any person who is on any ship or aircraft registered in India, wherever it may be, is also coming under the provision of this code. If you are traveling through a ship or through an aircraft that is registered in India, and any person in any place without and beyond India committing offense targeting a computer resource located in India. Now this was added by the amendment of, see, it is inserted by Act 10 of 2009. Any person in any place without and beyond India who is committing an offense targeting a computer resource located in India. Okay? This is section 4. So section 2, 3 and 4 are dealing with what? Intra-territorial and extraterritorial jurisdiction. Very good. Shaktija has given that answer in the chat box also. Now coming to section 5. Section 5 आता है, ठीक है? Section 5 is talking about what? Section 5 आता है MP की judiciary मैंने देखा है. Now section 5 is an exception. Okay, it's an exception to section 2 only. It's a saving clause. Section 5 जो है, it's a saving clause, it's an exception. Certain laws not to be affected by this act. Nothing in this act shall affect the provisions of any act for punishing mutiny and desertion of officers, soldiers, sailor, airmen in the service of government of India or the provision of any special or local law. So this is a saving clause that is excluding the application of code over some matters. जहाँ पे specific laws already present है, वहाँ पर हम इसे exclude कर सकते हैं. So it is limiting the applicability of the law to specific classes of people जहाँ पर different law is already existing. So section 5 is telling that Indian Penal Code is not going to interfere or not going to affect with any special law, with any local law on matters of punishment, on matters of mutiny, desertion of officers, sailors, soldiers, airmen who are working for government of India. So we say that section 5 is an exception to section 2. Section 5 आता है वैसे, ठीक है? So it's a saving clause, it's an exception to section 2, which is making the code applicable universally within the territory of India, ठीक है? But also where it is limiting the application of the code relating to the prescription and punishment. Okay, because we already have acts ना, Army Act, Air Force Act, Army Law Act, तो वहां पे वही acts continue होगा. 3, 4, 5. Hope this chapter 1 is clear to everyone. 2, 3, 4, 5, all this section. Now coming to explanations. Explanation देख लो, मैंने आपको already बता दिया है important sections, ठीक है? तो वो आप देख लेना, पढ़ लेना. यहाँ पर मैंने जो देखा है इन MP मैन वुमेन का डेफिनेशन तो हमेशा आता है सेक्शन 10. मैन डिनोट्स अ मेल ह्यूमन बीइंग, वुमेन डिनोट्स अ फीमेल ह्यूमन बीइंग. पर्सन आप देख लेना, who is a person. It includes company or association or body of persons. Then again, something which comes is public servant. Okay, who is a public servant, ये आता है, section 21 is important. So section 21 अच्छे से पढ़ना. Wrongful gain, wrongful loss again is important. 23, section 23 is again important. Wrongful gain is gain by unlawful means of property to which the person gaining is not legally entitled, and wrongful loss is loss by unlawful means of property to which the person is legally entitled. So 23 is important. ठीक है. Dishonestly, fraudulently का definition आप देख लेना, difference देख लेना. What is the difference between section 24 and 25? What do you mean by counterfeiting? Okay. 29A जो है ना, वो भी आप एक बार देख ही लेना, बिकॉज ये जो भी हमारे अमेंडमेंट से आया है, एंड दैट टू रिलेटिंग टू इलेक्ट्रॉनिक रिकॉर्ड्स एंड आईटी एक्ट का, ये एक बार देखना है. द वर्ड इलेक्ट्रॉनिक रिकॉर्ड इन 29A विल हैव द मीनिंग असाइन टू देम इन क्लॉज टी ऑफ सेक्शन 1 ऑफ सेक्शन 2 ऑफ आईटी एक्ट. वैल्यूएबल सिक्योरिटी देख लेना, सेक्शन 30. इट वैल्यूएबल सिक्योरिटी डॉक्यूमेंट भी हो सकता है, ठीक है, और purports to be a document whereby any legal right is created, extended, transfer, restricted, extinguished, and so on. Act and omission क्या होता है? Act denotes a series of act. Omission denotes a series of omission. 34 is again important. Acts done by several person in furtherance of common intention. So when a criminal act is done by several person in furtherance of common intention, now this is again a very important section, ठीक है. Each of the person is liable for the act. मैंने अभी अभी joint liability जब आपको I was explaining joint liability जब समझाया था, so 34 is also coming under joint liability. It is making a person jointly liable. Okay. 35 देखो, when such an act is criminal by reason of its being done with a criminal knowledge or intention, each of that person who joins in the act with such knowledge or intention is liable for the act in the same manner as if it were done by him alone in his knowledge or intention. Okay, so this is again important. 35. So when you're reading 34, read 35 also once. And what is the effect caused partly by act and partly by omission? Wherever the causing of a certain effect or an attempt to cause the effect by an act or omission is an offense, is to be understood that the causing of that effect partly by an act and partly by an omission is the same offense. So यहाँ पे देखो एक illustration है, ये important है, ये illustration देखना. A intentionally causes Z's death, because application based questions are also coming in MP judiciary. आप इसको देख लो एक बार. 36 का जो illustration है, A intentionally causes Z's death partly by illegally omitting to give Z food and partly by beating him. So what has A committed? He has committed the offense of murder. So if you're partly doing an act and partly you're omitting, so he partly omitted to give Z food, that is also constituting a offense only. ठीक है. So whenever you are reading the sections, read it with the illustrations which is given here. Voluntarily पढ़ लेना. So let me ask you one question. आप answer दो. ठीक है. I'm just asking you a question. Please listen to this question carefully. Now say for example, A sets fire by night to an inhabited house in a large town for the purpose of facilitating a robbery, and he causes the death of a person. Then what do you think? Has he caused the death voluntarily or not? Do you think he has caused the death voluntarily or not? I'm repeating the question. A has set fire by night to an inhabited house in a large town so that he can commit a robbery, and he causes death of a person in this. So has he caused, what do you think, has he caused the death voluntarily, या फिर he was not intending death? Any answer to this? Start commenting, students. Did you understand my illustration? Please start commenting. He has set fire and that to a house which is inhabited so that he can commit robbery. So can we say he voluntarily caused death? चलो फटाफट बोलो. Khushi says, and Shaktija says voluntarily, ma'am, as he had knowledge of death because Khushi says voluntarily. Yes, the answer is correct, voluntarily. If you see the illustration to section 39, it is there, okay, and it is said to be causing death voluntarily. अच्छा, स्पेशल लॉ क्या होता है, लोकल लॉ क्या होता है? स्पेशल लॉ होता है जो पर्टिकुलर सब्जेक्ट को होता है, एंड लोकल लॉ इज अ लॉ एप्लीकेबल टू अ पर्टिकुलर पार्ट ऑफ इंडिया. इंजुरी जो मैंने पूछा था आपसे सेक्शन 44, इंजुरी इज वन ऑफ द इसेंशियल्स ऑफ क्राइम. इंजुरी इज वन ऑफ द इसेंशियल्स ऑफ क्राइम. ऑलवेज रिमेंबर बच्चा लोग दैट इंजुरी, दैट इसेंशियल्स इज डिफरेंट एंड stages of crime is different. ठीक है, stages of crime is different. It includes what are the stages of crime? Who can tell me? It includes what? Intention, preparation, attempt, and commission. है ना? Intention, preparation, attempt, and commission. So these are the stages or elements. Elements जो है या essentials है वो different है. So injury is one of the essential of crime and is defined in 44. Injury denotes any harm whatever illegally caused to any person in body, mind, reputation, or property. So it's not that injury you are only causing to a person's body. It can also be caused to his reputation or to his property or to his mind. अच्छा, माइंड में बताओ तो कौन सा आता है? हमने किसी के माइंड में इंजुरी कॉज की. माइंड मीन्स मेंटल हेल्थ को इंजोर करा है. सो वेयर विल इट बी पनिशेबल अंडर आईपीसी? और रेप्यूटेशन में अगर हम करते हैं इंजुरी तो कहाँ पनिशेबल है? आईपीसी में. और प्रॉपर्टी को करते तो किधर है? फटाफट कमेंट करो आप लोग. इंजुरीज बॉडी, चलो बॉडी को तो समझ में आता है, मर्डर, ग्रीवियस हर्ट, है ना, रेप, ऑल दीज आर ऑफेंसेस रिलेटिंग टू बॉडी. माइंड में कहाँ पनिशेबल है? और रेप्यूटेशन को अगर हम किसी के इंजोर करते हैं तो कहाँ पनिशेबल है? और प्रॉपर्टी को करते हैं तो किधर पनिशेबल है? राइट, गो ऑन कमेंटिंग. अच्छा, word life is section 44 5 denotes the life of a human being. Death denotes the death of a human being unless the contrary appears. Soumya says defamation 499. Very good, that relates to injury to reputation. Good. Okay, okay. Word animal denotes any living creature other than a human being. तो human being को छोड़कर जो भी living creature है, that is an animal. Okay. Good faith again is important. So whatever is done or believed without due care and attention. Nothing is said to be done or believed in good faith which is done or believed without due care and attention. So when you do something with due care and attention, that is said to be done in good faith. When you are doing something in good faith under section 52, remember section 52 is good faith. ठीक है, आता है एग्जाम में. और हार्बर क्या होता है? हार्बर इंक्लूड्स सप्लाइंग अ पर्सन विथ शेल्टर, फूड, ड्रिंक, मनी, क्लोथ. आप हार्बर कर रहे हो उसे, मतलब आप उसे शेयर दे रहे हो, आप उसे शेल्टर दे रहे हो, राइट? यू आर हार्बरिंग एन ऑफेंडर एंड ऑल दैट by giving him by supplying him with shelter, food, drink, money, all this. Shaktija has written cruelty 498. A cruelty is will be 498. A very good. Cruelty is one of the thing where mental injury is also included. Mental cruelty also is included. Very good, Shaktija. Yes, Soumya. Defamation is for reputation. And चलो प्रॉपर्टी का, प्रॉपर्टी तो हम जानते हो, offenses relating to property you have so many things: theft, robbery, dacoity, mischief, all these things. So they are also punishable. Now coming to the chapter of punishment. Punishment का chapter अगर आप देखो तो ये 53 से start होता है and it ends at 75. Chapter 3 of punishment starts from 53 and ends at 75. Now what are the kinds of punishment? How many kinds of punishment are given here under section 53? आप देखो यहाँ 6 punishments दिया है, but the third punishment is not, it's been omitted. So generally the first punishment is death. अगर आईपीसी में आपको क्या क्या punishments दे सकते हैं? Death दे सकता है, imprisonment for life दे सकता है आईपीसी हमें. imprisonment दो तरह का हो सकता है, that can be rigorous imprisonment, that is with hard labor या simple imprisonment also. Then आपके property को forfeit किया जा सकता है, that is also one of the punishments, and fine भी you is imposed. So these are the kinds of punishment under IPC. Right, so what are the kinds of punishment under IPC? See, it's given under 53. So it can be death, it can be imprisonment for life, it can be imprisonment which is of rigorous or can be simple. Then we have forfeiture of property and fine. ठीक है. अच्छा बताओ, डेथ कौन कौन से ऑफेंसेस में वी आर गेटिंग? वी गेट डेथ इन द ऑफेंसेस लाइक अंडर 121, दैट इज वेजिंग वॉर अगेंस्ट गवर्नमेंट ऑफ इंडिया. अब या 132 अबेटमेंट ऑफ म्यूटिनी, या 194 के अंदर अगर आप फैब्रिकेट कर रहे हो फॉल्स एविडेंस ड्यू टू विच इनोसेंट पर्सन सफर्स डेथ, 194 में. मर्डर 302 में आपको भी मिल सकता है डेथ पनिशमेंट. देन पनिशमेंट ऑफ मर्डर बाय लाइफ कन्विक्ट. Now, this section was actually struck down by Supreme Court because it was unconstitutional in the case of Mithu versus the state of Punjab. Writing it here, okay? Okay, so hope you all are understanding. Hope everyone is able to get what I'm trying to teach today, what I'm trying to say. Then abatement of suicide of minor या insane या intoxicated person के लिए भी आपको, yes, rarest of rare cases में, Shaktija, very good, yes, it's given. Okay, then attempt to murder by a person under who is already under sentence of imprisonment for life. So if hurt is cause section 307, kidnapping for ransom under 364A, and death with dacoity with murder, all these attract imprison death punishment. Okay, and then we have imprisonment for life. अच्छा, ये जो omitted, हाँ, imprisonment for life जो है, पहले the word which was used was transportation for life, but then it was substituted with imprisonment for life. So पहले जो word use होता था ना यहाँ पर, that was transportation for life, but now it is used imprisonment for life, and it means you are being imprisoned for the whole of the remaining period जब तक आपका natural life है, you are being imprisoned. So if you see section 55 now, 53 के साथ अगर आप 55 देख लो, in every case in which a sentence of imprisonment for life shall have been passed, 55 अगर आप देखो, ठीक है, in every case in which sentence of imprisonment for life shall have been passed by appropriate government may without the consent of offender commute the punishment for imprisonment of either description for a term not exceeding 14 years. So imprisonment generally means you are being imprisoned for the rest of your life, but section 55 ke according it should not be exceeding the appropriate government may with the consent of the offender they can commute this punishment to 14 years. Therefore, life convict is not entitled to automatic release on completion of 14 years imprisonment unless the government has passed an order, या फिर वो कंसिडर करते हैं ना, आपने मूवीज में देखा होगा, गुड बिहेवियर एंड कंडक्ट ऑफ कन्विक्ट, सो दे रेमिट और दे कम्यूट द रिमेनिंग पार्ट एंड दे लीव, उसके बाद आपको ऑटोमेटिकली रिलीज कर देंगे अगर आपने अच्छा बिहेवियर मेंटेन करा है, या इफ दे सी दैट दे हैव रीजंस टू कम्यूट योर सेंटेंस देन दे विल डू इट आफ्टर 14 years. They consider to release you. And a similar provision you can get in CRPC also, where you get a remission to the convict. Can anyone tell me that? It's section 432 of CRPC. ठीक है, अगर आप 57 देखो, coming to 57, fractions of terms of punishment, right? Now fractions of terms of punishment, if you see in calculating the fractions in terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. So if you are being imprisoned for life, it shall be reckoned as equivalent to imprisonment for 20 years if you calculate the fraction. बिकॉज क्या होता है ना, हम इम्प्रिजनमेंट जब देते हैं फॉर लाइफ, इट कैन बी रिगरस इम्प्रिजनमेंट ऑल्सो, it can be simple imprisonment also, it can be together rigorous for a fraction and simple for a fraction, right? Rigorous means generally when you are being imprisoned with hard labor, you have to work hard in the uh, prison also. ठीक है. Now there are some imprisonment where the possibility of release is not there, right? So if you see some sections, you will see that if a convict is awarded a life imprisonment, it means that he is being imprisoned till his death, मतलब जब तक वो वहीं पे उसको अब मरना है, till his life he will be in prison only. But he can be subject to release by the appropriate government, as we saw in section 55, 55 जहां पे commutation of sentence of imprisonment for life हो सकता है, right? जहां हो सकता है. Otherwise, the Indian Supreme Court has time and time again held that life imprisonment means imprisonment till the end of person's life, subject to the remission which he might get under 432 of CRPC and constitutional powers under 72 and 161. But there is a case, if you have gone through that case of Swami Shraddhananda versus the state of Karnataka, there also the court upheld the validity of the sentence, where the prisoner was, debarred from earning remission and from being eligible to be released prematurely. So court ने बोला कि नहीं, इसको आप premature release we are not going to give. So question before the court always which comes is that what will be the sentence, whether a special category of sentence instead of death for a term exceeding 14 years can be put right beyond grant of remission or not. These are some question. And अगर आप 55 देख रहे हो, तो 55 के साथ जहाँ पे हमें imprisonment for life में commutation मिलता है, डेथ के लिए भी commutation मिल सकता है in under section 54. So if death has been passed and the appropriate government feels that the punishment of death should be commuted, it can be commuted then. Okay, death sentence can also be commuted, right? So whenever you are being imprisonment, it can be under the third category, it can be rigorous. In rigorous means you have to work hard, means digging earth, आपको mining activities या फिर forest में वो जो cutting wood वाला activity है, वो सारी चीजें, mountains में भी बहुत सारी work होते हैं which is given, like पत्थर तोड़ना होता है और wood को काटना होता है, अर्थ डिग करना होता है माइनिंग एक्टिविटीज में, या फिर सिंपल इम्प्रिजनमेंट भी आपको मिल सकता है. सो सेक्शन 60 ऑफ आईपीसी, इफ यू सी, if I show you 60 of IPC, sentence may be wholly or partially rigorous or simple, right? So simple imprisonment तब मिलता है जब आपने कोई small offense किया है जिसका seriousness इतना ज्यादा नहीं है, like wrongful restraint or defamation. So in case of simple imprisonment, the convict is not forced to do any kind of hard labor, right? uh, but there are some imprisonment which is punishable with rigorous imprisonment. Like what, can you tell me, like which offenses are being punished with rigorous imprisonment? Anyone who can tell me, कौन से offenses में you get rigorous imprisonment? Anyone? Which offenses have rigorous imprisonment? Please start commenting in the chat box. Now forfeiture of property also is one of the uh, punishment, and then we also have fine, right? Now fine which is imposed according to section 63, if you see, what will be the amount of fine if there is no sum expressed? The amount of fine to which the offender is liable is unlimited but cannot be excessive, right? और अगर आप फाइन नहीं पे कर पाते हो, फाइन नहीं पे कर पाते हो, तो उसके ऑल्टरनेटिव में यू गेट imprisonment, right? So sentence of imprisonment for non payment of fine. If you don't pay the fine under section 64, you get imprisonment. Now, section 64 is divided into three categories. One is punishable with imprisonment and fine, one is punishable with imprisonment or fine, one is punishable with only fine. Right? So, for that, you just go through section 65, 67, and uh, what will be the nature of imprisonment if you are have not paid fine and all that. ठीक है. अच्छा, अब अगर हम 75 देखें, वो अभी हम यहाँ पे 75 अगर आप, अच्छा 73 एक बार देख लेते हैं सॉलिटरी कॉन्फाइनमेंट का जो सेक्शन है 73 में. If a person is convicted of an offense for which under his code the court has power to sentence him to rigorous imprisonment, the court may by its sentence order that the offender shall be kept in solitary confinement for any portion of the imprisonment to which he is sentenced, not exceeding 3 months, according to the following scale. That is, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months. If a time not exceeding 2 months if the term of imprisonment shall exceed 6 months and shall not exceed 1 year, and a time not exceeding 3 months if the term of imprisonment shall exceed 1 year. तो अगर हम किसी को solitary confinement भी देते हैं तो there has to be a there has to be a limit. That is, if I have if I'm imprisoning you for 6 months, so solitary confinement cannot be beyond 1 month. If I'm imprisoning you for more than 6 months and less than a year, solitary confinement cannot be for more than 2 months. And if I'm imprisoning you for more than 1 year, then solitary confinement should be maximum of 3 months. In any case which is beyond 1 year, 3 months से ज़्यादा solitary confinement हम नहीं दे सकते, right? In executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time, with interval between the period of solitary confinement of not less duration than such period. This is 74. And 75 talks about enhanced punishment for certain offences under chapter 12 or chapter 17 after previous conviction. What is chapter 12 and chapter 17 of Indian Penal Code? What is chapter 12 and chapter 17 of Indian Penal Code? Chapter 12 अगर आप देखो, it is offences relating to coin and government stamp. 17 is offences against property. So if a person is convicted second time for these offences, जो like offences relating to coin and government stamp, or in property, if they have committed any offense, then they are liable to greatly enhanced sentence, right? If they have been sentenced for more than 3 years imprisonment, they will be given an enhanced punishment. So the provision here is provided to create a more deterrent effect on the offender. Okay? Because they have already been previously convicted and again they have attempted the same thing. So that is why enhanced punishment will be given under section 75. Okay, now coming to punishment, एक question आप लोगों से पूछना है, what is the minimum punishment which is given under IPC? Minimum punishment given under IPC is for what? बताओ. What is the minimum punishment? Who can tell me the minimum punishment? पूरे IPC में सबसे ज्यादा like कम punishment किस section में दिया है और वो क्या है? Anyone who knows? What is the minimum punishment? Please start commenting on in the chat box. Minimum punishment. Shaktija has written rupees 20. Yeah, 10 rupees 10. Sorry, Shaktija has written rupees 10. Rupees 10 is right. Rupees 10 is right, but for a different thing. Can you tell me for what? Which section of IPC prescribes the minimum punishment? If you see section 510, 510 of IPC, okay, The minimum sentence which is prescribed in the in 510 of IPC, that is relating to this drunken state. Okay, it's relating to drunken state. I'll tell you 1 minute. Misconduct in public by drunken person, and the punishment is simple imprisonment for a term which may extend to 24 hours, or with a fine which may extend to 10 rupees, or with both. So this is the minimum punishment जो हम देखते हैं. ठीक है. 24 hours and rupees 10. Theories of punishment I'm not going through, but there are many theories relating to punishment. I hope you all know that. Like, yes, Khushi, correct. Like deterrent theory, retributive theory, preventive theory, and reformative theory. So we are not going to that. Now coming to chapter 4, again very very important section. I cannot miss any part of this section. Right? It is general exception. Now 76 अगर आप देखो, 76 अगर आप देखो, it is acts done by person who is bound or by mistake of fact believing himself bound by law. Right? Whenever you are doing this kind of sections, please make it sure that you do it with illustration. Don't miss the illustrations which is given under this chapter. Every illustration and every section of this chapter is important. Okay. So chapter 4 is, if you see, it's divided into sections which is from 76 to 106, है ना. 76 to 106, and 76 and 79 is concerned with mistake of fact. 76 and 79 अगर आप देखो, it is concerning with mistake of fact. Okay, please write it beside your Barak marginal note. 76 and 79 is mistake of fact. 77 and 78 is privilege acts and judicial act. 77 and 78 अगर आप देखोगे तो privilege act and judicial act है. Section 80 अगर आप देखो तो वो accidental acts है. Accidental act. 81 is related with doctrine of necessity. Very important. 81 is relating to doctrine of necessity. And 82 to 86, you will see all those acts which is, where a person is not capable to commit a crime. Like if it is committed by a child, he's known to be doli incapax. 87 to 90 अगर हम देखें तो it is acts which is done with consent. 92 is done without consent, still it is coming under general exception. 95 is talking about the trivial offenses, like law will not punish anyone for trivial offenses, which is under 95. There is a maxim also related with 95 na, de minimis non curate lex, like law does not take action on small and trivial matters, de minimis non curate lex. And private defense का chapter जो start होता है, that is from 96 to 106, right? So IPC, if you see section 76 to 106, it is divided into two parts. General exception chapter is divided into two parts. What are those students? Can you tell me? Excusable act and justifiable act. Some acts which are excusable and some are which are justifiable, and that is why they are coming under the chapter of general exception. मतलब अगर आप ये एक्ट करते भी हो, आपने क्राइम करा भी है, बट यू आर एक्सक्यूज और यू हैव डन एन एक्ट विच इज जस्टिफाइड, सो यू विल नॉट बी पनिश्ड. एक्सक्यूजेबल एक्ट के अंदर आ जाता है मिस्टेक ऑफ फैक्ट. ठीक है, मिस्टेक ऑफ फैक्ट like 76 and 79, and accident section 80, also infancy which is section 82 and 83, insanity which is under 84, and intoxication 85 and 86. And justifiable acts में आ जाते हैं judicial act. Judicial act means act of a judge or order of a court under 78, या फिर necessity under 81. ओके. या फिर 94 में आप देखोगे वहां पर भी है act to which a person is compelled by threat. Okay, then consent के भी अंदर justifiable होता है. Now consent can be given, it can be with consent or without consent. 87, 89 and 92 में ये आ जाएगा. Then we have 93, then we have trivial matters under 95, and we have private defense, which is again justifiable, 96 to 106. Okay, so there are some acts which are excusable, there are some acts which are uh, justifiable under this chapter. So person is innocent until he is proven guilty, we know that, right? But there is a presumption that every accused is innocent, and he is given a chance to prove himself innocent, right? That ठीक है, उसने act करा, crime हुआ, and injury भी हुई, but there was a there was a necessity, there was a justification for doing the act, or there was an excuse of doing the act, right? So we cannot doubt any person बिफोर, पहले से ही, पहले जब तक उसका गिल्ट प्रूव नहीं हो जाता, ही इज कंसिडर्ड टू बी इनोसेंट इन द आईज ऑफ लॉ. So if you see a mistake of fact, which I have told you, 76 and 79 mein mistake of fact is given. Please go through this. Now there are two things which is related with this. Okay, if you have heard of this maxim, ignorantia facti dot excusat, ignorantia juris non excusat. Have you heard of this maxim? What is the meaning of this maxim? Who can tell me? Ignorantia juris non excusat. Tell me the meaning. Ignorantia facti dot excusat. बताओ. Just post. Yes, very good. वेरी गुड सौम्या. इग्नोरेंशिया फैक्टी एक्सक्यूजेटिक है और एक इग्नोरेंशिया जूरिस नॉन एक्सक्यूजेट है. सो दैट मीन्स दैट ignorance of fact is excusable, but ignorance of law is not excusable. तो अगर आप ignorance of fact करते हो तो फिर भी चलो excusable है, and there are many cases also relating to that. Now when you come to 76 and 78, 76 says about acts done by person who is bound or by mistake of fact believing himself bound by law, right? And 79 अगर आप देखो तो it is act done by person who is justified or by mistake of fact he is believing that he is justified, he is bound by law. ठीक है. 76 का अगर हम illustration देखें, A who is a soldier, he fires on a mob by order of his superior officer in conformity with the commands of the law. A has committed no offense. A, an officer of a court of justice, being ordered by the court to arrest Y, and after due inquiry believing Z to be Y, arrests Z. A has committed no offense. And if you see 79, acts done by person who is justified, he's under a mistake that, or he's under a mistake that he's justified by law to do it. So A sees Z committing what appears A to be murder, और उसको लगता है कि अच्छा इसने मर्डर करा, उसको लग रहा है कि इस पर्सन ने मर्डर करा है, so he seizes Z in order to bring Z before the proper authorities. Again, he has committed no offense here also. So this means that there are two factors here. One is that you are ignorant of law, and one is mistake of, sorry, ignorance of fact, and one is mistake of fact. Okay, so in ignorance of fact में that means you don't know anything about it, and mistake of fact admits कि knowledge है लेकिन आपने properly वो समझा नहीं, right? So these are the two. 76 and 79 is concerned with defenses of mistake of fact only. Okay. Now coming to 77 and 78 again, which is judicial act, coming under judicial act. 77 and 78 अगर हम देखें, act of a judge when he is acting judicially. So if a judge is acting judicially and he is doing something which is wrong, it is not considered to be an offense under section 77. And 78 says act done pursuant to the judgment or order of court. अगर कोई भी इंसान कोर्ट के जजमेंट या कोर्ट का ऑर्डर उसके परसुएंस में कुछ करता है, तो दैट इज ऑल्सो नॉट एन ऑफेंस इफ दैट इज बीइंग कैरिड आउट इन गुड फेथ. So 77 is the act of judge when he is acting judicially, and 78 is act done pursuant to the judgment or order of court. Right? जज का डेफिनेशन कहाँ है बताओ फटाफट. आईपीसी में जज डिफाइंड किधर है? Where is judge defined under IPC? Tell me fast. If you see section, very good, Shaktija. Yes, 19. 19 defines a judge, right? So if you are acting judicially or if you are acting in pursuant of a judgment or order, that is again immunity is granted to you. So immunity is granted to judges, immunity is granted to magistrate also under CRPC provisions also. So these are again not, these are again uh, exceptions. Okay, so even if you have committed something, you are not punishable. Coming to 80. Now 80 is again an important section. It relates to accident. ठीक है, किसी ने अगर कुछ accidentally करा है, that is also coming under a defense only. तो अगर आप 80 पढ़ो, नथिंग इज एन ऑफेंस विच इज डन बाय एक्सीडेंट और मिसफॉर्च्यून. अब क्या करें अगर एक्सीडेंटली हो चुका है कोई चीज, है ना, या मिसफॉर्च्यून, एंड आई डिड नॉट हैव एनी क्रिमिनल इंटेंशन और नॉलेज ऑल्सो. There is no criminal intention or knowledge. And the act which is done is a lawful act. It is done in a lawful manner. It is done by lawful mean. And it is done in good faith. In that case, it will not amount to offense. If something is done in accident, right, and without criminal intention, without any knowledge, and in the doing of a law, I was actually doing a lawful act in a lawful manner with proper care, with proper uh, caution also. Still, if something has happened, then I am not liable. And what is the illustration? A is at work with a hatchet. The head flies off and kills a man who is standing by. So here, if there was no proper caution on the part, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Coming to 81, 1881 is very important. It is concerned with doctrine of necessity. Concerned with doctrine of necessity. एक बार आप लोग प्लीज 81 पढ़ो और उसका illustration पढ़ो. I will not read the illustration. You all read the illustration once. And till then, I'll just take a minute break. Okay, I'll drink some water. Till then, you all read 81 illustration. Okay, students, so coming back to doctrine of necessity, hope you all have gone through it. So, section 81 talks about necessity. Please yaad rakhna. And it comes from two maxim. The maxim is quod necessitas non habet legem. That means necessity knows no law. And necessities vincit legem. That means necessities overcome the law. तो अगर आप ingredient देखो section 81 का, it should be done without any criminal intention, and it is done in good faith. It is for the purpose of avoiding a greater harm to a person or property, and the harm which was to be avoided must be imminent, and it has been done in to avert a greater harm, right? So necessity, if you see, right, there is a it's a it's a very important thing. Necessity is a very important thing. लेकिन कुछ कुछ चीजों में नेसेसिटी हम नहीं कर सकते हैं, राइट. One cannot take life for self preservation, and there can be no necessity that justifies homicide. This was said in the case of R versus Dudley and Stephen. A very important case when we do necessity, R versus Dudley and Stephen per lena is right. Sorry. R versus Dudley and Stephen is a very important case on doctrine of necessity, जहाँ पे ये लोग ship, like, they were actually, they lost their way in a boat, and they sacrificed a minor boy uh, to eat him. The boy was about to die, but इन्होंने क्या किया, बाकी members ने क्या किया, उसको sacrifice करके they started eating him so that they can survive for some more time. And they were convicted of murder later, but they took the doctrine of necessity, that was for self preservation. But the court said no, self preservation, you cannot take life for self preservation, or necessity cannot justify any homicide. और इसके जो दो illustrations है ये भी काफी आते हैं in application based question, which is one relating to a ship. और वो ship ऐसे जा रहा है कि either it can, there are 20 or 30 passengers on board in the ship. So if he does not change the course, then the ship will either, ship को danger है जिसमें 20 to 30 passengers है, और अगर वो course change करता है, then it will run down a boat with only 2 passengers on board. ठीक है. So what will you do? Will you kill 20 or 30 passengers, or will you take risk of these 2 to 3 people who are on a small boat? So doctrine of necessity will come. So there is a choice between two evils. दोनों ही evil है, बट अगर आप अवॉइड करना चाहते हो तो आप ग्रेटर डेंजर को अवॉइड करोगे, राइट. एंड सिमिलरली ए इन अ ग्रेट फायर ही पुल्स डाउन हाउसेस इन ऑर्डर टू प्रिवेंट द कॉन्फ्लिग्रेशन फ्रॉम स्प्रेडिंग. सो अगेन ही इज डूइंग दिस इन गुड फेथ टू प्रिवेंट अ ग्रेटर इविल. ठीक है. So this is 81. Then come to 82, which is act of child under 7 years of age, and act of child above 7 and under 12 years of immature understanding. 82 and 83 dealing with infancy. Now 82 comes up with a concept of doli incapax. Writing that in the chat box. 82 अगर आप देखोगे तो डोली इनकैपेक्स, that means a child is not capable to commit a crime, तो हम उससे exception में ले आते हैं. ठीक है. So a child who is below 7 years, he cannot commit a crime, he is completely immune from IPC का provisions. And if a child is above 7 but below 12 years, again they say that he might be, it depends upon his maturity and understanding. So 82 is providing absolute immunity to a child who is below 7 years of age because he is duly incapacitated. Section 83 is providing qualified immunity. Please remember this. Section 82 is absolute immunity, while Section 83 is qualified immunity to a child who is above 7 years but below 12 years. Now, he has to prove to the court that he doesn't have the maturity or understanding to understand the nature of consequences. So, he can take that defense of infancy. Okay, 82 is absolute immunity, 83 is qualified immunity. Remember it. Coming to insanity, like act of a person of unsound mind. ठीक है. 84 talks about people who are unsound mind. Now पागल लोग जो होते हैं, unsound है, insane है, who are not who cannot understand again the nature of the offense they are doing, they are due to their unsoundness of mind, they can take this defense, right? And they can escape the criminal liability. So one who is insane, he has no mind, he cannot have necessary mens rea to commit a crime. So again here it's an absolute defense. Okay, because the act of insane person is unintentional, it is involuntarily. तो यहाँ पे तीन प्रिंसिपल्स आ जाते हैं. अ मैड मैन हैज नो विल, that is called furiosi nulla voluntas s. या फिर a madman is like one who is absent, furiosus absentis lowest, and a madman is punished by his own madness. तो वो बेचारा मैड है, यही उसका पनिशमेंट. अब उसको और क्या पनिशमेंट दे? furiosus furor sui punior. That these are the following principles relating to unsoundness. ठीक है. So the basic ingredient, if you see, of section 84, that the accused is non compos mentis, act is contrary to law. That means a man by reason of delusion is unable to differentiate between right and wrong, and his state of mind at the time when the offense is committed, ये भी हमें देखना है, right? This also needs to be seen. And the test of insanity is in this rule called M Norton rule. मैकनॉटन rule एक है, आप वो पढ़ लेना, relating to insanity. ठीक है, मैकनॉटन rule. So there they have considered the level of insanity and what are the test of insanity. मैकनॉटन rule. ठीक है. Now coming to 85, and 85 relates to intoxication, 86 also relates to intoxication. What about a person who is intoxicated, right? Will he be punished or not? So intoxication is again a general defense, because when you consume alcohol, it is of course associated with crimes of violence. So intoxication जो है उसका effect जो है is equivalent to unsound mind, we can say, right? Intoxication. Yes, Shaktija, I will type those maxim. Do you want the maxim relating to insanity? Okay, I'll just type those maxims which I told you right now relating to insanity, correct? A madman has no will, furiosi nulla. I'll just type it. Just wait, I'm typing that. Okay, so I have given that rule also, McNaughton rule, and a madman is punished by his own madness, furiosus furor supunior, and man has no will, that is furiosus nulla voluntas est, right? A madman is like one who is absent. Furiosus absentis lovis. Okay, so I have just written those maxims here. Now coming back to this intoxication. Now intoxication is like insanity only. Okay, so a person starts behaving like an unsound mind only when he is in the uh, drunken state. ठीक है, तो intoxication is also a defense. अभी इंटॉक्सिकेशन इनवॉलेंटरी भी हो सकता है या वॉलेंटरी भी हो सकता है. Involuntary or intoxication is given under 85 and voluntary intoxication is given under 86. 85 में इनवॉलेंटरी है और 86 में वॉलेंटरी इंटॉक्सिकेशन है. तो 85 is giving protection to those people if at the time of committing an offense he is in a state of intoxication and he was incapable of knowing the nature of the act. ठीक है, and he has administered the drink without his knowledge or against his will. So he is in a state of intoxication, but the thing that has been intoxicated is against his will or without his knowledge. It has been administered to him, so he will be not he will not be liable relating to that. Now, what if he has done a voluntary intoxication? So, if an act is done under self induced intoxication, it will amount to an offense. Only when you don't know that you are being administered some drug or something which might make you intoxicated, then you are given that defense. But agar aap self induced intoxication karte ho, then it will amount to an offense if the even if the doer is incapable of knowing the nature of the act or whatever he is doing is in contrary to the law. तो ही इज नॉट इंटाइटल टू एनी इम्यूनिटी फ्रॉम क्रिमिनल लाइबिलिटी बिकॉज ही हैज सेल्फ. तुम खुद ही ने, वरना अगर अगर हम ऐसे इंटॉक्सिकेशन वाले लोगों को इम्यूनिटी दे देते, डिफेंस लेने को दे देते, तो क्या होता, सब लोग ये प्रूव कर देते दैट ड्यूरिंग कमिशन ऑफ दैट क्राइम दे वर इंटॉक्सिकेटेड. सो वॉलंटरली ड्रंकनेस इज नो डिफेंस, right? So one who is drunk should be punished when he is sober. And the thing is here, q peccet ebrius lot sobrius, that means one who is drunk will be punished when he is sober. Okay, I'm writing that maxim here. Just typing the maxim here. Okay, please bear with me little bit, students. We will finish up till chapter 15 today only. Jitna hoga I'll try to complete it today. ठीक है, क्यू पैकेट एब्रियस लुअत सोब्रियस, देखो मैंने दे दिया. if you are in a drunken state, you are committing sins, fine, you will be punished when you are sober. So if an act is done and you are doing an act which is an offense, and if you are doing it in a state of voluntary administered intoxication, then you are going to be punished. So in cases where an act done is not in cases देखो, not in cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have done if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. So if you can show that it was against your will, right, then you will get the benefit of this exception. But if you are doing something which is self administered, then you are not getting the benefit of this section. Now come to 87, 88 and 89. All are concerning consent, voluntary, non-fit injuria. 87, 88 and 89. Now 87 is act not intended and not known to be likely to cause death or grievous hurt done by consent. Right? There is an illustration. A and Z agree to fence with each other for amusement. So they have agreed to fight with each other. And with the consent of each other, they are suffering any harm in the course of such fencing may be caused without foul play, and if A while playing fairly hurts Z, at A commits no offense. So if someone has voluntarily, he has given this consent, right, knowingly that he might be hurt, और इस केस में अगर आप किसी को हर्ट करते हो, मतलब अगर कोई फाउल प्ले नहीं है एंड एक्सीडेंटली या फिर इन द कोर्स ऑफ दैट गेम यू गेट हर्ट, देन यू आर कमिटिंग नो क्राइम. दिस इज व्हाट 87, 88, 89, 90 में भी कंसेंट ही है हमारा. सो consent is something which can be from 87 to 92, you will see it is consent which is completely exonerate. There are some offenses which are based on consent also, like if you are raping a minor girl, okay, raping a minor girl, and there are consent which is mitigating the offenses like murder, okay. There can be implied consent also, like receiving stolen property. And offenses, even if consented, are punishable, as you can see in section 91, and from 312 to 316 where we will see. So consent is basically, that means you are doing something deliberately or with your will, okay. सो आप 87 टू 90 में अगर आप देखोगे तो कंसेंट से ही रिलेटेड चीजें हैं. एंड कंसेंट इज, इफ यू सी हियर 90, consent known to be given under fear or misconception. What about consent of insane person and consent of child? So here I'll just tell you about the illustration. Act not intended to cause death, done by consent in good faith for person's benefit. So here a surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under a painful complaint, but not intending to cause Z and intending in good faith Z benefit, performs the operation, A has committed no offense. ठीक है. Acts done in good faith for benefit of child or insane person or by consent of guardian. So if some person is doing something for the benefit of a child in good faith, and if they have not taken the child's consent, right, has his child cut for the stone by a surgeon. Say for example the child is suffering something and they go to the surgeon and they operate him out. The guardian has given consent but the child has not consented, right? So again, they have done no offense. The guardian or the person who is doing that for the benefit of the child has done no offense, right? Now consent should be free. ठीक है, हम consent ले या दे रहे हैं, that should be free, it should be voluntarily, it should not be under fear or misconception. So if a consent is under fear or misconception, then it is not a consent. ठीक है. So 87 talks about consent by a person above 18 years for act other than death or grievous hurt. 88 अगर आप देखो, it is for the benefit of a person above 12 years other than for death. 89 is consent of guardian for person below 12 years or for person of unsound mind. And 92, if you see, it is act without the consent of the person or guardian. उस केस में क्या होने वाला है, ठीक है. Now I'll quickly move to 93, communication made in good faith. So if someone is making communication in good faith and due to that communication someone is injured, it is coming under general exception. Like a surgeon in good faith communicates to a patient his opinion that he cannot leave. The patient dies in consequence of that shock. So A has committed no offense. Okay. 93, communication made in good faith. See the illustration also. Acha, 94, act to which a person is compelled by threat. And 95 is act causing slight harm. Now this is 95 is related with the maxim of de minimis non curate lex. Okay, I'm writing it here. Section 95 is de minimis non curate lex. That means law will not take into action small and trivial things. सो अगर हम राइट अगर कुछ ट्रिवियल मैटर है तो वो सारी चीजें यहाँ पे कवर नहीं होंगी. एंड फ्रॉम 96 to 106 वी हैव 10 सेक्शंस रिलेटिंग टू प्राइवेट डिफेंस. ये इंपॉर्टेंट है. 96 says things done in private defense. Nothing is an offense which is done in the exercise of private defense. So if you are doing something which is for your own private defense, it is not an offense. Coming to 97, right of private defense of body and property. Every person has a right subject to the restrictions contained in section 99. So 99 को छोड़कर 99 में जो भी restrictions है, subject to that, every person has a right to defend his own body या body of any other person against any offense which is affecting the human body, right? This is again one part. Or he can also defend his property, whether movable or immovable, of himself or of any other person against any act which is an offense falling under the definition of theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. Right of private defense against the act of a person of unsound mind. ठीक है? So like say for example, Z has under the influence of madness he is attempting to kill A. तो अगर एक पागल इंसान अगर आपको इंज्योर करने की कोशिश कर रहा है, right? So Z तो will be coming under the exception only. He is guilty of no offense. But do you have a right to private defense against him? Yes, A has the right of private defense against the mad person also. नाउ देर आर सम एक्ट सेक्शन 99 में देर आर सम एक्ट जहां पे आपको राइट ऑफ प्राइवेट डिफेंस नहीं मिलता है. ओके, यू डोंट हैव अ राइट ऑफ प्राइवेट डिफेंस. वेयर डोंट यू हैव अ प्राइवेट डिफेंस राइट? Against an act which does not reasonably cause the apprehension of death or of grievous hurt if done or attempted to be done by a public service servant acting in good faith under color of his office through that act. Okay, so you cannot see, these are the acts where you don't get a right of private defense. If it is not reasonably causing the apprehension of death, ठीक है, any act which is not reasonably causing the apprehension of death is not covered here, or grievous hurt if it is done or attempted to be done by a public servant acting in good faith under color of his office through that act may not be strictly justifiable by law. There is no right of private defense against any act which does not cause the apprehension of death or of grievous hurt if done or attempted to be done by direction of public servant also. So if he's being done by public servant or being under the direction of public servant, you don't have a right to private defense against them. And there is no right of private defense in cases where there is time to have recourse to protection of the public authorities, right? So if you have time to recourse to the protection, like you had the time to call the police officer and they might have come, but still you have taken the step, then you don't have a right to private defense there also. These are the explanation what is the extent to which you can exercise your right. अभी अगर एक इंसान मेरे को स्टिक से मार रहा है, in my private defense, if I open fire, if I shoot him, that is not allowed. ठीक है, प्राइवेट डिफेंस आपको प्रॉपरली एक्सरसाइज करना है. 100 देखो, when the right of private defense of body extends to causing death, in which cases you will have your private defense extending to causing death, right? These are the cases like assault with the intention of committing rape, or an assault which gives an apprehension that grievous hurt will be caused. तो इन cases में आपका private defense उस हद तक जा सकता है जहां you can also cause the death of the person who is trying to assault you, और with the intention. तो अगर कोई रेप करने की कोशिश कर रहा है और अपने आप को बचाने में अगर रेपिस्ट को हम मर्डर कर देते हैं, दैट इज ऑल्सो कवर्ड अंडर सेक्शन 100. So you can protect your body in this way. An assault with the intention of kidnapping or abducting and all this. 101 says when such right extends to causing any harm other than death, if the offense is not of the description which is given in 100, then you can only cause other thing, but it should not cause death. You can cause other harm but not death. And कब से commence करता है ये right of private defense of body? It commences as soon as the reasonable apprehension of danger arises. सेम 103 में when right of private defense of property को डिफेंड करते करते आप कब, अगर डेथ कॉज हो जाता है तो किन केसेस में यू आर कमिंग अंडर द एक्सेप्शन? रॉबरी अगर हो रही है और अगर उसमें अगर हमने एक रॉबर अगर मर गया तो वी विल बी कवर्ड अंडर राइट ऑफ प्राइवेट डिफेंस. यस, समवन इज ट्राइंग टू break my house at night, commit house breaking at night, then also I get this right to kill him. और mischief by fire, मतलब right to kill him as in if necessity is requiring, और उस केस में अगर he dies, then I'll get this exception of 103. All these cases, okay, which is mentioned here, four cases. And same thing, 104 and 105 may, when will it commence and all that is written here. And 106, if you see, right of private defense against deadly assault when there is a risk of harm to innocent person. So if I have a danger, if I am apprehending कि someone will assault me, and in order to protect me, अगर मेरे हाथों किसी innocent person का uh, के लिए harm या injury if I cause, then what is the thing that will not be an offense. See, A is attacked by a mob who attempt to murder him. He cannot effectually exercise his right of private defense without firing on the mob, and he cannot fire without risk of harming young children also mob में जो mingle है. So A is committing no offense if by firing he harms any of the children. Right? This is 106. 106 also is important. The illustration part is important. I hope this part is clear to everyone. Now let me move to abatement chapter. Abatement आपको पता है, abatement देखो in 107 important है, तो I am just going through 107. Now I'll be only going through the sections. 107 देखो important है, मैंने आपको मार्क भी करवाया था. Abatement कैसे होता है? By instigating any person. Okay. So abatement under 107 can be by instigating any person to do thing, or engaging with one or more other person in any conspiracy for doing that thing, or intentionally aiding by act of illegal omission the doing of that thing. And the explanation here says a person who by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate that thing. So in abatement कैसे होता है under 107? 107 to 120 is relating to abatement. Now abatement is an inchoate offense, मतलब incomplete offense है. सबसे पहले तो आप ये समझ लो abatement कैसा offense है? Inchoate. I'm writing it. Inchoate offense means it is incomplete offense. अपने में वो complete नहीं है, because I'm just abating someone, right? And it might amount to some action or preparation of committing another crime. Now abatement, when you see, abatement can be now in English law there are different types of accessories also. Okay, act of abatement is to aid, and either you are assisting in giving the aid, you are commanding, you are encouraging, you are instigating, all this is covered under this thing only. And the person who is not committing the crime but he is abating will be guilty of abatement of that offense. Now there are different types of accessories, like accessories before fact, like those who are helping the offender before the commission of crime, or accessories after fact, those who help after the crime is committed, like in hiding and escaping. Principals in first degrees, they are offenders who are actually committing the crime. Principals in second degrees, they are those offender who do not commit the crime but are present at the crime scene. ठीक है, ये सारी भी चीजें हैं. तो अगर आप अबेटमेंट देखो तो अबेटमेंट तीन चीजों से हो सकता है, बाय वे ऑफ इंस्टिगेशन, बाय वे ऑफ कॉन्स्पिरेसी. सो बाय वे ऑफ इंस्टिगेशन, बाय वे ऑफ देखो कॉन्स्पिरेसी, या फिर बाय वे ऑफ इंटेंशनली एडिंग दैट पर्सन. ठीक है, तो इन चीजों से हम अबेटमेंट कर सकते हैं. एंड सेक्शन 108 टॉक्स अबाउट द अबेटर. हु इज एन अबेटर विथ एक्सप्लेनेशन, दे हैव कंप्लीटली प्रॉपरली बता दिया इन्होंने कि कहाँ कहाँ अबेटर किस चीज, अबेटर किसको बोलेंगे 108 के अंदर. एंड देयर आर एक्सप्लेनेशंस आल्सो, प्लीज रीड देम अलोंग विद द illustration. Illustration is very important regarding abatement. ठीक है. अच्छा, ये 111 थोड़ा important है. Liability of abater when one act is abated and a different act is done. So I have abated some other act but you have committed some other act. In that case what is the liability? 111 देख लो एक बार. When the act is abated and a different act is done, the abater is liable for the act done in the same manner and to the same extent as if he had directly abated it, provided the act done was a probable consequence of abatement and was committed under the influence of instigation. तो यहाँ पे अगर आप देखो, A is instigating a child to put poison in the food of Z, और उसको food भी दे दिया. तो चाइल्ड ने फूड में पॉइजन मिला दिया, ठीक है, लेकिन उसने मिस्टेकनली वाई के फूड में पॉइजन मिला दिया. Okay. Now, child is under the influence of A's instigation. So, whatever he has done is a probable consequence of the abatement. So, here will A be liable? A ये नहीं बोल सकता अरे मैंने तो Z के फूड में बोला था, इस अबेट बच्चे ने Y के फूड में मिला दिया. No, A is liable in the same manner to the same extent as if he had instigated the child to put the poison in the food of Y. Right? Abatement is an important chapter. Please go through it once, students. Go through abatement chapter once with illustration. 120 तक है, ठीक है. Coming to criminal conspiracy, which is what is the definition of criminal conspiracy? What do you mean by criminal conspiracy, students? It's given in the 120A and 120B. अगर आप देखो, the punishment is given for criminal conspiracy. So when two or more persons agree to do, how many persons are required in criminal conspiracy? Remember it, two or more. How many people are required in criminal conspiracy? Please mention in the chat box, two or more. So the minimum requirement is two. Or cause to be done an illegal act, an act which is not illegal by illegal means. ठीक है, ये देख लो एक बार आप, क्रिमिनल कॉन्स्पिरेसी क्या होता है देख लो. So 128 talks about illegal act. Now where is illegal act defined under IPC? If you see section 43, you will see illegal act ka definition, right? So if two people are agreeing, there is agreement between two people, या two is the minimum requirement, उससे ज्यादा भी हो सकता है. An illegal act or a legal act which is done by illegal means. So you are agreeing to do something in criminal conspiracy, right? Now, conspiracy by way of abatement under 107 is also mentioned. Remember that. So criminal conspiracy का definition आप देख लो, और illegal act जो यहाँ दिया है, that is defined in section 43. And why is criminal conspiracy made punishable? Because there is an agreement between two or more persons to do an unlawful act, or you are doing a lawful act only but by unlawful means, right? So conspiracy can be very like, there can be a wheel chain of conspiracy. Say for example, if I, A, B and C are entering into an agreement to commit an offense, ठीक है, ए बी एंड सी ने हायर करा है किसी और को टू प्रोवाइड पिस्टल फॉर एग्जीक्यूटिंग द प्लान, राइट? सी इज हायरिंग डी फॉर एग्जांपल टू प्रोवाइड पिस्टल फॉर एग्जीक्यूटिंग द प्लान. E also is entering and he is also becoming part of conspiracy. F is also becoming part of conspiracy. He is also agreeing to accompany. G is also agreeing. So all this wheel chain, everyone will be liable. All will be liable for criminal conspiracy. So it is like a partnership in crime. And in each conspiracy, this common plan to execute the common plan, if you are coming in, then it is considered to be criminal conspiracy, जिसका आप सेक्शन 10 ऑफ इंडियन एविडेंस एक्ट में भी देख सकते हो. वहां पे भी क्रिमिनल कॉन्स्पिरेसी से रिलेटेड चीजें बताई गई हैं, ठीक है. अबेटमेंट और क्रिमिनल कॉन्स्पिरेसी में डिफरेंस है, राइट? वो भी आप थोड़ा पढ़ लेना. अबेटमेंट इज डिफरेंट फ्रॉम क्रिमिनल कॉन्स्पिरेसी, रिमेंबर दैट. एंड दिस इज द punishment which is given. Now coming to chapter 6, which is of offenses against state, very important. 121 is very important again. 121 says about waging or attempting to wage war or abating waging of war against the government of India. So whoever is waging the war against government of India or is attempting to wage war or abates the waging will be punished with death. The person will be punishable with death, imprisonment for life, and shall also be liable to fine. And है, okay, और नहीं है, he will be given fine also. ठीक है, like A joins an insurrection against government of India, then he has committed an offense under 121. And there can be conspiracy to commit offenses punishable by 121. 121 A के अंदर वो conspiracy में भी हो सकता है. Coming to important part, which is 124 A, that is sedition. Now sedition is an important part when you read this chapter of offenses against state. Chapter 6 में sedition again एक important चीज है, right? 124A sedition, right? So what is the meaning of sedition under 124A? What is sedition? It is kind of, people say it is a kind of treason which a person is committing, right? It is an act or an attempt, and where you are by word either spoken or written or by signs or visible representation, you are bringing or attempting to bring in hatred and contempt or some excitement or attempting to excite people and dissatisfaction towards the government of India. And this act must be towards the government established by law in India. So this will be the act of sedition, which can be by words, which can be by signs, which can be by visible representation. Now, words can be spoken, it can be written also. To bring hatred against the government of India or to excite dissatisfaction among the people against the government of India. Okay, this is sedition. And the natural consequences would be hatred, contempt, dissatisfaction as given under the section. Okay. एक्सप्लेनेशन भी दिया है, देखो डिससैटिस्फैक्शन क्या होता है, मतलब डिसलॉयल्टी एंड फीलिंग्स ऑफ इनमिटी, right? All these are also given. So sedition is in under 124A. Chapter 7, as I told, we can skip chapter 7. Chapter 8 में unlawful assembly देख लो आप, 141. ठीक है, 141 देख लो, unlawful assembly. What is unlawful assembly, students? See how many people are needed for offenses against public tranquility. How many people are needed in unlawful assembly? Please comment. An assembly of 5 or more persons. We will finish up by 3:30. Okay, don't worry. We will finish our thing by 3:30. Only I'll be taking the last thing. Okay, we won't extend beyond 3:30. 141 देख लो आप, an assembly of 5 or more person who are designated an unlawful, they are designated an unlawful assembly. देखो कितने लोग यहाँ required है, 5 or more person. And if the common object is this, what is the common object of this assembly? It is to overawe by criminal force or show of criminal force the central or any state government or any public servant in the exercise of lawful power, to resist the execution of any law or any legal process, to commit any mischief or criminal trespass or other offense by means of criminal force or show of criminal force to any person, to take or obtain possession of any property. Fifth is this, to compel any person to do what he is not legally bound to or to omit what he is legally entitled to. Right? So this is the object of unlawful assembly. And an unlawful assembly under 140 one will require how many people? Minimum 5 people. Criminal conspiracy ke liye minimum 2 people required, right? Unlawful assembly is 141 to 145, and also 149. Section 149 is also related to unlawful assembly. Also you see rioting, which is from 146 to 148. Affray is 159 and 160, right? So this we have to see. And under 149 अगर आप देखो unlawful assemblies punishment पढ़ लेना, punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. 149 अगर आप देखो, यहाँ पर हम क्या क्रिएट करते हैं 149 के अंदर? एक जॉइंट लाइबिलिटी क्रिएट करते हैं. Why? Because under section 141 you are overawing the state by criminal force, or you are resisting the execution of any law, you are creating mischief or criminal trespass, committing of mischief or criminal trespass by criminal force. You are obtaining some possession or you're compelling any person to do or not to do an act, right? So it should be an assembly of 5 or more person under 141. And the essential ingredients are that under 149 it creates a joint liability for a common object, है ना? तो कॉमन इंटेंशन एंड कॉमन ऑब्जेक्ट में दो डिफरेंसेस आप पढ़ना. कॉमन ऑब्जेक्ट एंड कॉमन इंटेंशन जो हमने पढ़ा है, कॉमन इंटेंशन अगर आप देखो इट्स अ रूल ऑफ एविडेंस. कॉमन ऑब्जेक्ट इज अ सब्सटैंटिव ऑफेंस, राइट? एंड in common object you require minimum 5 people. Common intention के लिए minimum 2 people. Remember all this. Now coming to rioting. What is the section of rioting, students? What is the section of rioting? 146. यहाँ पे कितने क्या कौन लोग लग रहे हैं और क्या कर रहे हैं ये लोग? इफ बाय फोर्स और वायलेंस इज यूज्ड इन अनलॉफुल असेंबली. सो 5 या 5 से ज्यादा लोग अगर अनलॉफुल असेंबली के मेंबर्स हैं एंड दे आर कॉमिटिंग फोर्स और वायलेंस, right, in prosecution of common object, then every member is guilty of rioting under 146, and this is the punishment: 2 years, extending to 2 years, or with fine or with both. And if you are writing with deadly weapon, then that punishment can go to 3 years or with fine or with both. Okay. Coming to 159, which is affray. Affray is committed by two people, two or more persons. So minimum requirement in affray is two. Okay, if you are fighting in a public place, you are disturbing the public peace, you are committing affray, and that can extend to a month or with fine or with a fine which may extend to 100 rupees or with both. This is affray. Right, so पढ़ लेना एक बार. Unlawful assembly, rioting, affray, and punishment. Whenever you are reading, please read with the punishment also. Chapter 9 we can skip. मैंने इंपॉर्टेंट सेक्शंस जो बोला है बस आप उसको एक बार देख लेना. चैप्टर 9A का मैंने आपको बताया था, ऑफ ऑफेंसेस रिलेटिंग टू इलेक्शन. इसमें आप एक बार सारे सेक्शंस देख लेना कि किस सेक्शन में क्या दिया है, किस सेक्शन में क्या है. सेक्शन ही बेस्ड क्वेश्चन आ सकता है और उससे ज्यादा कुछ नहीं. राइट, 171 defines candidate and electoral right, 171B is bribery, 171C is undue influence at election. Now 171D is personation at election, like someone is, you know, in a fictitious name. If you are voting for some other person, that is personation. You are showing that you are some other person. Okay, you are actually voting in the name of some other person, whether the person is living or dead. आप किसी और के नाम पर अगर वोट देते हो तो that is personation at election. Okay, what is the punishment for bribery given under 171E? So just remember these sections, that's it. Chapter 10 we can skip. Okay, chapter 10 we can skip, but 170 कुछ कुछ sections मैंने आपको बताया था, like furnishing false information under 177. As you can see, I told you some sections, right, for this. uh, so you can just go through 177 and all that little bit. बस आप देख लेना कि क्या सेक्शन, मतलब मैंने बताया ना, जो इम्पोर्टेंट है उसको पढ़ना है बिल्कुल डेप्थ में. अदरवाइज आप सिर्फ उसको बेयर एट रीडिंग ही करो, या फिर उसका वो मार्जिनल नोट आप याद रखो. फर्निशिंग फॉल्स इंफॉर्मेशन 177. 181 में देर इज दिस फॉल्स स्टेटमेंट ऑन ओथ और अफर्मेशन टू पब्लिक सर्वेंट. फिर मैंने बताया था कि ये बस देख लेना. यहाँ पे रिफ्यूजिंग ओथ और अफर्मेशन व्हेन ड्यूली रिक्वायर्ड बाय पब्लिक सर्वेंट इज पनिशेबल अंडर 17 is given punishable under 178. Refusing to sign statement punishable under 180. This is it. And chapter 11 of giving false evidence. So giving false evidence is here 191 में it's given. If you are giving false evidence, of course you will be punished for that also. Like A, in support of a just claim which B has against C for 1000 rupees, falsely he swears on a trial that he heard Z admit the justice of B's claim. So you have given a false evidence here, and that is punishable. Okay, giving false evidence is punishable, or fabricating false evidence is punishable under 192. So for example, if A puts jewel into a box belonging to Z with the intent that they may be found in the box, and then Z will be convicted of theft. तो हम देखते हैं ना मूवीज में कि किसी ने किसी के बॉक्स में या अलमीरा में या रूम में ज्वेल्स रख दिया, so that they will be punished for theft. So you are fabricating false evidence, and if you are doing that, you will be punished, right? You will be punished for that. So this is regarding of false evidences and offenses against public justice. 201 आप देखो, causing disappearance of evidence of offense or giving false information to screen offender. So if I by any way am causing any evidence to disappear, yeah, if I'm screening an offender, I'm trying to save him, then also I'm punishable, right? I'm punishable for that also. 212 देखो, हार्बरिंग ऑफेंडर. सो इफ यू आर गिविंग शेल्टर टू एनी ऑफेंडर. हार्बर का मतलब हमने कहा देखा था, वेयर इज हार्बर डिफाइंड. इफ यू सी, हार्बर इज डिफाइंड अंडर 52A. सो 52A में हार्बर है, एंड 212 में हार्बरिंग एन ऑफेंडर इज गिवन, right? So if you are concealing some offender, you believe him to be an offender and still you are harboring him with the intention that you will make him escape from legal punishment, then also you are punishable. If it's a capital offense, then this is the 5 years is the punishment. Okay, if it is a punishment for which you are harboring an offender who will be punishable for death, for life, or with imprisonment, then it you will be punished for harboring him for 3 years, which might extend to 3 years, and shall also be liable to fine and all this, right? इसको यहाँ तक देखते हैं, and then we will quickly come to chapter 15. Chapter 15 is regarding offenses affecting public health, safety, convenience, decency, and morals. It starts from 268. Now, 268 defines public nuisance. What do you mean by public nuisance? So, if you are causing common injury, danger, or annoyance to the public or to the people or in general who are actually dwelling or who are occupying a property, or which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have the occasion to use any public right, then you are creating public nuisance, and it is not excused on the ground that it was caused for some convenient or advantage. ठीक है? उसके बाद अगर आप negligently you are spreading some infection or disease, जैसे कि कोविड टाइम्स में हुआ था, राइट? मैलिग्नेंट एक्ट लाइकली टू स्प्रेड इन्फेक्शन, अगर आप जानबूझकर ऐसे करते हो, या फिर इफ यू आर डिसोबीडिंग द क्वारंटाइन रूल, आपको पता है ना कोविड टाइम्स में ये काफी आया था, राइट? क्वारंटाइन रूल, सो प्लीज गो फॉर इट. Just read this section, just read. Adulteration of food or drink intended for sale, sale of noxious food or drink is also punishable. Adulteration of drugs is also, adulterated drug ka sale is also punishable. And important which comes here is the obscene wala thing, the selling of obscene books. If someone is selling obscene books, yeah, or if you are selling obscene objects to young person, or obscene acts and songs, if you are in that thing, then also these are punishable. So obscenity under IPC, false evidence, giving false evidence under IPC is punishable. Read those sections. Obscenity is punishable, public nuisance is punishable. ठीक है? तो obscenity अगर आप देखो इसका definition, so you will find that in very brief, if I tell you, if you are selling some obscene book जो represent करता है by way of pamphlet, paper, writing, drawing, किसी भी तरीके से अगर आप कर रहे हो, तो ये सारी चीजें भी punishable हैं. Okay? And there is a test. Please remember this test which I wanted to tell you, that is Hickling test. Obscenity से एक टेस्ट रिलेटेड है, वो आप एक बार देख लेना. Hickling test, right? Now, the Hickling test is a proper test in our country. It is an alternative test जो सुप्रीम कोर्ट ने ले डाउन किया था इन द केस ऑफ अवीक सरकार वर्सेस स्टेट ऑफ वेस्ट बंगाल. ठीक है? जहां पे कम्युनिटी स्टैंडर्ड टेस्ट मीट करे गए थे रिलेटिंग टू व्हाट इज व्हेन द क्वेश्चन ऑफ ऑब्सिनिटी इज सीन, देन आप किन चीजों को आप ऑब्सीन बोल सकते हो, कम्युनिटी टॉलरेंस टेस्ट कितना होना चाहिए, ये जजमेंट हमने देखा है इन अवीक सरकार वर्सेस स्टेट ऑफ वेस्ट बंगाल. And then there was another case which came after that, was Devidas Ramachandra Tuljapurkar versus state of Maharashtra. There these Hickling test was given, right? Now obscenity can also be over internet. So when the question has come into light only in recent time, because increasing use of social media also is there, and so obscene things are also done in internet. So वहां पर भी कुछ केसेस हैं जिसमें सुप्रीम कोर्ट ने रूल किया है दैट इफ यू नो अक्यूज्ड कैन, इफ द अगर चार्ज 67 ऑफ आईटी एक्ट में है, ओके, देन द अक्यूज्ड विल बी पनिशेबल. बट अगर 67 ऑफ आईटी एक्ट में वो कवर नहीं होता है, देन यू कैन नॉट प्रोसिक्यूट हिम अंडर 292 ऑफ आईपीसी ऑल्सो, राइट? सो किस तरीके से हम ऑब्सनिटी को लेंगे, दैट इज ऑल्सो चेंजिंग इन इंडिया. दैट इज अगेन अ बिग question to which we can determine later, or we can just read about it, because again it is debatable in many forms, what is obscene, what is not obscene. But For now, you can just go for the Hicklin test and read about it, as I told you about the two cases also. That was Avik Sarkar versus the state of West Bengal, and also go through the Devidas Ramachandra Tuljapurkar versus state of Maharashtra 2015 case. So with this, we will finish off our first part of IPC. Okay, chapter 15 you don't have, you can skip, but some sections I have already told you, just go like read it. Okay, acha is section mein ye hai, is section mein ye hai. If you injure or if you defile place of worship with intent to insult the religion of any class, it is under 295. Disturbing religious assemblies under 296. Trespassing on burial places is 297. Uttering words with deliberate intent to wound religious feeling is punishable under 298. So this is what you will be doing today. Tomorrow we will continue with chapter 16, which is now we will cover some important sections tomorrow. Okay? Relating to body, relating to property, relating to marriage. This will be done tomorrow. I hope you all enjoyed the session today, and you will go through all the sections which I have told you today, all the important sections from part 1. Tomorrow I will give you the important sections from part 2 also, though I feel offenses a general exception chapter, abatement chapter, criminal conspiracy chapter. Again I'm telling you, general exception, conspiracy, abatement, okay. Then this part where we have sedition and offenses against government of India and state. These are all important chapters, these are all important sections, so please go through them. Second part I'll discuss tomorrow. Thank you everyone for your patience. I'll see you tomorrow. All the best with your preparation, students.